We are back on Morning Line. Thanks for joining us. The number 737-7587. If you have any legal questions about power of attorney, about setting up a estate for later in life with us, this is Barbara McGinnis from Takacs and McGinnis. It's always good to have her on as a regular guest. She and Tim come on and join us via Zoom, and it's good to have you on. So Barbara, what else do we want to touch on this morning with regard to some of the common mistakes in estate planning? Like you're right, you overlook the digital assets, which I had not even thought about. So that's the first time we've ever talked about that. What else should we touch on?
Well, let's think about that, because things change in our lives, right? Sometimes things change in our lives, but sometimes things change in the wide world. And those changes should drive you to update, well, at least review and perhaps even revise your estate planning documents.
Sure.
So just thinking that you have your documents in place and that you don't ever need to touch them again is a misconception. It is not a one and done. Estate planning is a process. Just like you don't put your money over in your financial advisor's hands and say, I don't need to know anything anymore. You just leave it right there and let life take its course.
Yeah.
You stay involved, you update accordingly because things change. So don't get upset if your documents need to be revised. Your previous attorney probably did not do a thing wrong. Your life is just different. Maybe it's different because there's new people in your lives, marriages and births. Maybe because some people have left your life through death or divorce. Maybe you have a new diagnosis that drives you into thinking more seriously about incapacity or end-of-life planning. But maybe there's just been law changes. That we're seeing a lot of talk, We're hearing a lot of information about proposed tax changes that will drive a lot of folks into a new estate plan or a revised estate plan. Just like increased use of digital assets and online life is going to drive people in to make sure their estate plan is equipped to manage those assets as well. So thinking it's a one and done process that you never have to touch it again, that is a mistake that people make.
Right. I mean, you're right. Things change. But I mean, when you say changing estate planning and stuff, the first thing that always comes to my mind isn't so much what you were just, I think, referring to there. It's more like, I want to change who I'm going to leave my assets to. Or you want to make an adjustment to your will and say, I don't want to leave as much for her. I'm going to leave more for him, or I'm going to put more money here.
Right.
Now, that's always happened, but you're just saying there's a whole broad field of things. Obviously, your income can change, tax things, all that you may have to revisit.
Right. Good reasons to at least touch base with your estate planning attorney, probably every 3 years or so, just to see if there's been any significant change in taxes or other laws that would impact your estate plan. Sometimes things get easier, like when the estate tax limit went way high, like the $11 million. Well, a lot of the old planning strategies to minimize taxes became a moot point because the estate law was so high. So now we're looking at it's probably going to go back down to about the $5 million mark next year, a little bit earlier than what we'd planned. Probably won't cause a big change for most of us who do not have $5 to $10 million estates. But for some people, that it's going to be a game changer.
Yeah, it's interesting when you talk about estates. Just to determine the total value of your estate, that takes into a what? Okay, I guess it's pretty basic. But to determine what your worth is, that's property, assets of all types, taking into account the debt, and then what you have cash-wise in the bank and any investments. Is that basically it?
That's it, and then however your capital gain is going to be calculated depending on your certain assets. Now, let's talk about capital gain, because people tend to fear taxes because most of us don't really understand taxes. But if we want to gift, and gifting is often an estate planning mistake that people make. They want to gift assets for different reasons. Sometimes it's because they think if they give it away, then it doesn't count for nursing home purposes. Sometimes they think it's just, well, it's easier than my kids having to go through the probate process. I'm going to give assets away. But be careful what you give away, because some assets appreciate, like real estate could appreciate, and you're giving away the old tax basis when you give that piece of asset away, right?
Sure.
So if I give my house, or maybe I give an investment account, or maybe even a sizable coin collection. You know, for example, say I give something away that I bought at a certain level that has risen in value to a new level. We call that appreciation. And that difference is taxable. So it's better for folks to inherit those kind of assets so they get the step up in basis. The last thing we saw yesterday about the proposed tax changes, it still includes the step up in basis, so it doesn't look like that's going away anytime soon. That's a good thing. So be careful what you give away. Really need to talk through that with probably not just your attorney, but your accountant as well. So all assets, we've talked about the importance of a will, how a will goes through probate, but everything you own is not a probate asset. And folks get confused by that sometimes. And we can own assets jointly with other people. Sometimes we mean to own assets jointly with other people, like with our spouse or something. Sometimes we don't really mean to own assets with other people, like when we put a child's name on our bank account, just for the convenience sake of the child having access to funds in an emergency situation. They could continue to pay bills, or death. They could pay final expenses because accounts are going to get frozen after death. But they could have unintended consequences of co-ownership, meaning last person standing is going to be the owner of that asset. Maybe you didn't mean for one child to inherit over all the other children. So anyway, joint assets is a way of passing title to at death that doesn't have anything to do with your will. Beneficiary designations. So updating beneficiary designations on things like your retirement accounts, life insurance policies, all of those, IRA, 401k, 403b, all of those types of accounts have beneficiary designations.
And they ask you that too, right? I mean, just to be clear, I mean,
Yeah.
you say update, but whenever you open one of those, even if you don't think of it yourself, they'll ask you to do that. And I have beneficiaries. Now, that may change, and you want to update that. And Barbara, hold on. We have a call that may be in reference to one of the things you've touched on before we get too far from that. Let's squeeze in the call real quick from Betty in Bowling Green. And Betty, good morning. Did you have a question for Barbara?
Yes, I do. I want to explain a few things. First, I have a house, and it's paid for. But about 10 years ago, I put my son's name on the deed with mine. And so anyway, he's got an older brother that's disabled, and a brother that's passed away that's got one daughter. Anyway, I wondered if when I pass away, will he have to go to probate court since this deed is in his name too?
Do you have a will? Do you have a will?
Yes, I do. I've got a will, but it's everything's will to him.
Okay, so Barbara, what do you think? And she's still on the line if you have to ask a question for more information.
Okay, so it's real important to know, how do you own the house with your son?
Right.
In a deed, on a deed, you can own property as tenants in common, which would mean that that it might still need to go through probate, and he wouldn't necessarily own all of that property unless your will said that he did. Or you can own it as joint tenants with a right of survivorship. And that means that if you pass away, your son that's on the deed with you would own all of that, would own that home. in its entirety. Now, if there's still a mortgage on that home, he would have to refinance. He's going to be responsible for the mortgage as well.
All right, so do you think there's a chance? I get the sense that she's looking to see what they can do to make sure it doesn't end up going to probate if they get all the paperwork done. Yeah. If she has him in the will, go ahead, ma'am. What were you going to say?
There's no mortgage. Nothing's on the home. Nothing owed.
Okay, nothing owed on the home. Okay. He's on the deed, and in her will, she leaves it all to him. If that's fairly straightforward, unless some of the others challenge the will, I mean, which I don't think is going to happen, could he avoid probate, or do you think it kind of goes through and it's just kind of real quick and easy?
It should be absolutely fine. Again, it matters whether it's a tenants in common or whether it's has a right of survivorship attached to it. If the deed calls for a right of survivorship, it will just all pass to her son. If it calls for a tenants in common, it goes through probate, but he will wind up owning all of it.
Gotcha. Typically,
so that's worth a check. That's worth a check, Betty, to see how that deed is drafted. Pull out your deed. Yep. Look for those words.
The words she needs to look for is what?
Right of survivorship.
Right of survivorship. All right, as we go to the break, that's something Betty in Bowling Green look for. Does it say right of survivorship? If that's in there, then it should pass to him, correct?
Right.
Gotcha.
And the other thing I just feel obligated to say is I don't practice in Kentucky, and so Bowling Green's in Kentucky. She may need to see a Kentucky attorney if she has questions.
Yeah, and that's a good point. As Barbara states, the laws can vary to some degree from state to state. So we'll take a break on that note. Barbara, we'll come back. Final segment with you. We'll hit on a few more key items right after this.